And like we always receive a lot of questions regarding patents, but in many cases we are not competent enough to answer them. So we decided to do this webinar and invited a registered USPTO registered patent agent, Mr. Chaim Factor, who has been doing this for many years. I think he has like pretty broad experience, like in management, in international and national patent law, as well as just business management. He has some C-level positions and had experience filing and preparing all sorts of patent applications, and he will be basically like the host today. He will be the person talking about the patents and answering your questions. By the way, thank you for the questions that you sent. We'll talk about them later, closer to the end of the webinar. But if you have some questions that will come up during the webinar, please feel free to ask them in chat. If you go to the bottom of your window, you will see a chat button right close to the share button. So just press the chat button, and then you can address the question to Chaim. Like you can basically like pick him from the list, or you can address it to me, and we'll ask it by the end of the webinar. So I guess at this point, Chaim, I'm passing the lead to you, and welcome everyone. And like Chaim, I think it's your turn now.
Okay, Konstantin, thank you. Want to say good afternoon, good evening to whoever's joining us today. Just a word or two about myself. Yes, I'm U.S. registered patent agent, very similar to a patent attorney in terms of handling patents and quite a few other aspects of IP law. It's just about identical. However, the requirements in U.S., for example, registration of trademarks are different, and patent attorneys would do that. In either case, as Konstantin has mentioned, I have some pretty broad experience in business development and engineering, in addition to my background of just about 20 years in patent work and in IP work. So frequently when I'm working with clients, or when our group First Tech Ideas is working with clients, we can bring that all to the table. We also work with people throughout the United States, and for that matter, we have associates in the major countries in Europe and in the Far East too, China and Japan, so that if you would ever have an interest or desire to go outside the US, we can help you as well. Anyway, today's presentation will be about 25-30 minutes. We'll have time for questions, and as Konstantin mentioned, if you have any questions along the way, feel free to chat them over. That's me. I just have to adjust something here. There you go. Okay, so today what I want to talk about are the following subjects: an overview of IP and also the expression IP protection, to talk about more specifically about patents, and most specifically about a utility patent, which is what most people think about when they talk about patenting, but there are other types, and we'll touch on that. Talk about government and attorney fees and give you some real numbers, so that when you make a decision to move ahead with your invention to apply for a patent, you have an idea of what the budget involves. It's an important thing, and I frequently mention that to my clients. Once more, talk about the costs, and also try to address the question, why not do it myself? And as Konstantin had mentioned, and I had mentioned, we'll have time for questions. Okay, so an overview. IP protection. What does that mean? What's IP protection? Well, actually, it's kind of the protection you get when you sign a contract or any type of an agreement. And most people think about IP protection like this lock that I'm showing you here on a gate, or a raincoat, you know, that's a force field. And neither is exactly correct, but both a contract or a lock are good. And a lock is only good for an honest man. If you have a patent in place, if you're working with reputable people, you do have very good protection for infringement. Of course, if you're not working with people that are that honest or whatever, you may have problems. But in general, IP protection expression, it's nonetheless useful in business and commerce, and we'll touch on that more as we go along. Just a general comment, you know, you can always think about going to court and having to defend your rights and so forth, and there are many rules about developing IP protection and patent protection in case that happens. But in many, many, many cases, that never happens. It's like a lock on a gate. Most people, in most cases, see a lock and from a distance of 50 feet or from 20 meters away or from even 100 meters away, see that there's a lock and they don't go near it and they respect your rights. So why formalize your IP, intellectual property? Well, the logical reason or the formal reason is to avoid infringement, just that I mentioned before, and to preserve your rights just in case you end up in court. Again, it's not a usual case. However, not all IP needs registration and application, and I'll give you a couple examples of other categories of IP that may or may not need formal registration. First one's copyright. Copyright is basically any original creative work done by anyone. For example, this slide presentation right now down here is copyrighted by me because I put it together. But copyright also applies to books, to songs, and in some cases even software. Another type of IP that really you don't formalize in terms of registration is a trade secret. A very famous example would be the formula for Coca-Cola, and some cosmetics and other types of products have this. There are kind of rules for trade secrets, and they can be effective, but in the world of patents, it's not applicable. But again, this is an example of IP. Trademark is also part of the framework of IP, and a trademark could be defined as an original symbol or a combination of characters. There's a more formal definition, but that's a summary definition. Trademarks can be registered or not registered. In each case, in both cases, one important part of a trademark is that you have to be using it so that you have any future protection. And of course, there are patents. There are 3 types in the US. One type of patent in the US is called a plant patent. Again, most people that deal with utility patents don't deal with it, but a plant can be patented if it's a distinct and new variety of a plant. I don't want to go into any more detail, but that does exist. There's also a thing called the design patent, which is throughout the world mostly is called the design. And that in general is an ornamental design of a functional item. It could also be an ornamental cover. Basically, a design is anything that you see that is both novel and you have protection of. And I'll give you some examples, one example of a design patent in another slide or two. And of course, there's the world of utility patents, the 3rd type in the United States. 2 types of utility patent formations. The first is called the provisional patent application. Most people are familiar with that expression. I call it a PPA just for short. But I give a really strong warning here. A provisional patent application does not ever become a patent on its own. In order to proceed from an application to receive a patent, you have to file a non-provisional patent. So from more or less from this point on, except for maybe an example of a design patent, I'm going to talk about utility patents and non-provisional utility patents. Okay, in the utility patent, you usually have 2 types of directions where the invention is described, and you're talking about either an apparatus, which is a device, a structure, having systems or parts, components, and this device or structure has a functionality too. And some examples of an apparatus would be an aircraft, a corkscrew, a radio. You know, there's a huge range of devices that have structure and function. They would be an apparatus. On the other hand, another aspect of utility patent, which is kind of another way of looking at things, you may have this or you may have only the apparatus. It's called a method. A method would be a combination or a sequence of steps. An example would be business methods. Another example would be steps in the software, and maybe not the software completely itself. A very common example too would be recipe. Take a 1/4 cup of this, mix it with a half a liter of water. Take the thing and put it in an oven for 400 degrees for half an hour and so forth. Step 1, step 2, step 3. Frequently, but not always, when writing patent applications, we touch on both apparatus and method, but in some cases, only apparatus is correct or only method is correct. Here I have some examples now. Apparatus examples. These are old ones. This is one from 1900. It's a structure. It's an oscillating bathtub. It has a function, and this was patented, wow, about 118 years ago, right? Even more. Another old one, even older, 15 years older, is a structure. Sort of looks like a one-wheeled bicycle. The structure has a function, and they were patented. Incidentally, about 100 years ago, and probably even 60, 70 years ago, patents weren't, they had maybe one drawing or two drawings and very little bit of text. Today, they are a bit more formalized, and there's usually a lot more text and usually more drawings associated. Here's an example of a method. It's a recent one. When I say recent, it's from the year 2000. This would be a method of a virtual sales personnel, and it's basically a sales engine. I would think how the sales are handled, how the money is handled, and how the information is transferred. And this looks very modern, and I chose it on purpose because it is relatively modern. And most people wouldn't associate with this being a patent, but you definitely can get a patent on the United States and other countries on a method as long as you follow the legal requirements and proceed that way. An example now of a design patent, and I start with the drawings of a design. Doesn't take too much imagination to realize that we're looking at some sort of a smartphone design, right? Usually with designs, you have at least 4 views, sometimes 6 views. The way these figures are numbered, I see this is figure 3, 4, 5, 6, 7, 8. I don't know what 1 and 2 were, but this is the front view of a cell phone, the back view, top view, bottom view, one side and the other. And that's very typical of a design showing all the different views. What's interesting about this design patent, and here's the actual front page, it was made by this little company called Apple Incorporated from Cupertino, California. I'm sure you've heard of them before. Turns out that sometime, I said 2010, that's right, the other one was 2000. This is relatively recent. It's only about, 8 years maybe. There was in the past, I think 4 or 5 years, huge fireworks between Apple and Samsung, and it was all pinned down because of design patents, and there were literally hundreds, I think, of millions of dollars involved in legal action. Again, this isn't applicable for us in terms of going to court and legal action, but there are many, many clients and many, many situations where you do have design patents and they're useful. Okay, a word about IP or patent protection outside the United States. There are many international agreements. Probably the most famous and the most basic one is the Paris Convention, which is now about 130 years or so ago. It allows a 12-month priority period for patents and a 6-month priority period for trademarks and designs. Priority period basically is the period right after you filed. It started by filing, and you're entitled to that period to make other filings in other places, and they will respect the initial filing date. I can give an example of that in another slide or two. One thing I have to emphasize, there's no such thing as an international patent. There is an international patent application, but you can't apply one patent application and expect to get protection in many different countries, or more correctly, to get a patent in many different countries. Patents are granted country by country only. Some countries do have a multilateral framework. A famous one would be the EPO, the European Patent Organization. There is also one, I believe, in the Far East in Asia. But even those multilateral framework organizations involve future or subsequent work where you have to file country by country. Now, there is a thing called the PCT, Patent Cooperation Treaty. It's a little bit out of our scope of talk today, and it would be called an international patent application with the word international and application. But even a PCT application, you need to go to national, to country by country later on. Okay, this slide is like, I call it meat and potatoes. It gives you an introduction to some of the costs, to at least to know how to budget if you're going ahead with the patent work. There you go. PPA, Provisional Patent Application. So you're talking about the attorney costs or the patent office costs. So in the next few paragraphs, each time I emphasize the word attorney and USPTO. Those are the two components of cost. To write and file a PPA, you need to turn to attorney usually to get help. The cheapest possible way to do it with online with probably poor quality is to spend about $250. Going into a formal office, you'll probably spend about $1,500 or more to do that. And to file your PPA, the minimum cost is $70. The maximum cost is probably $280. I can give some examples of the USPTO costs and why they vary. That will be the next slide. Regarding the attorney costs, I can emphasize that our office is normally at the lower end. We don't do PPAs for $250, not at all, but we are at the lower end of this, and we are at the lower end of the other ranges we give beneath. Now, as I mentioned, if you really want to proceed to receive a patent, you must file a non-provisional patent application. So writing and filing a non-provisional patent application, you'd have an attorney fee anywhere from about $2,800 to closer to $5,000. There's a range, and it depends on the material. The USPTO fee would be a minimum of $430, and depending on a number of variables, it could be as high as or exceed $2,500. Again, knowing the range and knowing where you are will help you build a budget. Now, once you've filed your non-provisional patent application, you have to do prosecution, which is also called office action responses. You have to respond to rejections and questions from the patent office. And this usually or virtually always happens at least once and typically twice or more. There are times when you can file a patent application and immediately, meaning after the first filing, get a patent. We've had that happen to us in 2017 twice, but it's rare. Many patent attorneys that I talked to thought that that was amazing. We were very happy. Our clients were happy, but since 2017, we haven't had it. But hey, we're looking ahead maybe to the rest of this year or next year. But normally, you should be prepared for 2 or more responses and prosecution. When that happens, your attorney costs are going to be on the order of $700 to $1,200. The USPTO cost, the fees, would be on no money whatsoever if you file on time, and you may have to file time extension fees, which could be $500 or more, depending on when you file. Another example of the cost of to be aware of it when you finally do get a patent, and again, that could be anywhere between less than a year or maybe a few years after you file. The attorney fee for this normally runs between $75 and $200, $150. The USPTO issue fee is a minimum of $250 and usually a maximum of $1,000. Now, all of these numbers are roughly representative as of September 2018, but of course there is some variation.
Chaim, can I ask one question?
Sure, go ahead. Go ahead, Constantine. You still with me?
Yeah, I'm here. Our customers often ask a question, if you file a provisional patent application first, and then you decide to go to a non-provisional patent application, like within that year, would that affect the cost of a non-provisional patent application?
It really depends. Especially if you've done one of these jobs, where it's usually very, very skeletal and not much information, I would say no. In other words, you probably won't get a deal. You probably won't get any consideration because there's probably not much information to go by. On the other hand, and I sort of touch on this question indirectly as we go on, if you're going to get more professional help, usually the provisional patent application, even though it's a first step, is written more formally, is written with more meat on the bones. In that case, yes, you may get, you know, if this is the $1,600, for example, you may get a break on some of this. So it really depends what your first step is and how you've moved ahead. And that may be a reason for, you know, considering a bit higher budget for your first step for the provisional. Okay?
Okay, thank you.
Okay. I think this timeline that I put together may give a better perspective to help out too. Here's a timeline which starts at 0 months, goes 12, 18, and 30 months. And against the timeline, I talk about the typical fees, which I've already mentioned in the previous slide, and the events that happen. Well, at 0 months, you're usually writing and filing whatever it is. Let's consider a non-provisional patent application. When you first file, that's your priority date. In other words, if today is the 26th of September, if we were to file tomorrow, our priority date for our non-provisional application would be the 27th of September, 2018. That date is important to keep in mind, especially for the 12-month Paris Convention time, in which we can file in different countries and still get credit, or up until the 12 months, we can file a PCT application. And I use the word credit, but it means we can still, up until 30 months, still have the 0, meaning that the first filing date, recognized for other applications. It's not so straightforward in this talk today, but the timing is important. Moving ahead to 12 months, we may have had an accelerated prosecution in the United States. We may have had to pay for a prosecution, or we may already have had a patent issued. Our office has frequently, and I think if I can, Vadim has an issued patent. I did see it was issued already, Vadim, you should know. Well within a year. There's a mechanism in the United States. We've been working with our clients to work from start to finish, from 0, well within 12 months, sometimes even 7 or 8 or 9 months to get a patent. So that can happen definitely within 12 months. And as I mentioned, the Paris Convention deadline falls at 12 months. So if you do want to go into other countries, you should file before 12 months or file your PCT to extend that time. 18 months. There's usually no fee associated with it, but publication takes place if you filed a non-provisional patent application of any type. Within about 18 months, give or take a few days, it is publicized and people know. It's not publicized, it's published and people can see it. Excuse me. Once more, the 30 months is a deadline for the PCT period, and you may also do filing up into that period, or may have prosecution in issue, and that's the PCT deadline. Now, I mentioned a couple slides ago that there are variable costs related to mostly the patent office fees. And the question is why? Well, the first major example in the United States is that you have 3 categories of paying fees. It used to be up until, I think, about 20, 30 years ago, there was only one fee category, and that was the full fee, 100%. But about, I think about 15, 20 years ago, I don't know exactly, but it certainly exists for quite a while. The USPTO came across with a small entity fee. They wanted to give people and smaller businesses a break, and that means a 50% discount, half the rate of the regular entity. And about, I think, 5 years ago, roughly, they said, you know what, we have really small entrepreneurs, people that don't have a background in patenting, or at least less than 4 applications, don't have a lot of resources. We'll give them a really good break, and we'll give them the micro entity and give them 25% off. So it's basically 25%, 50, and 1. These would be big companies like IBM. These would be companies maybe on the side, or organizations that have 10, 20 employees, or maybe even 50, but fulfill the category of a small entity. And these would normally be small entrepreneurs or very small companies. Other examples of patent office fees: when you file a non-provisional patent application, if you're filing more than 20 claims at the end of the application, or more than 3 independent claims of the 20, you have to pay extra money. It's not a huge amount, but if you do have like 30, 40, 50 claims, something that was very traditional in the past and is much less now, even paying $20, $30, $40 for each claim, that can add up. Another example is a track 1 fee. I mentioned a few slides ago how we've helped many of our clients get an application from start to finish in as little as 8 or 9 or 10 months. There's a fee to be paid to the USPTO. For a micro entity, it's just in excess of $1,000. But we've found from our experience that both in terms of the acceleration and also saving time in prosecution, that it's worth the money. There are time extension fees. You normally get 2 or 3 months to return, to come back with an answer, to respond each time you get an office action. If for whatever reason you need more time, you normally can get extended for at least another 2 or 3 or 4 months, sometimes up to 6 additional months, but you do have to pay time extension fees, and they are according to the 25, 50, and 100% rates. And another example of a patent office fee would be the issue fee. They too are according to the micro, small, and regular entity. Patent offices, meaning, excuse me, attorney offices as opposed to the patent office, also have a variation, and I did touch on that a few minutes ago, and will touch on that in a slide or two. Okay, I'm pretty well along the way now, and I just want to mention, should anyone have a question, please make sure you note it, and we'll try to get to it. People frequently ask, why not do it myself? Well, the basic answer is you can do it yourself. Legally, you have every right to do it, and the patent office respects it and would even encourage and has tools. But frequently, we have people come to us who've tried to do it themselves, and this is what's happened. And the reason why you have to consider the risks of errors or even losing your rights or impairing your rights are pretty big if you're going to go ahead and move ahead and try to formally get a patent. It can definitely generate additional costs because of errors or additional fees. And in many cases, you lose time as you may miss deadlines or you have to extend procedures. One of the things that we've learned over the years is that not only is patent law and the requirements dynamic and changing, there are many things that impacted. Even the fees are changing from time to time, but some of the laws and requirements change, and that's probably our expertise. I guess one analogy, and I have this little diagram here, is that, hey, would you want to do that yourself? So yes, you can, but you may want to have somebody that you can trust doing it for you. Okay, this is probably one of my last slides, and it kind of is a good introduction to Konstantin's information in his next slides. Why do I want a patent? Well, one comical question could be, well, just to impress, a girlfriend or a boyfriend. But a more serious reason is maybe you want to commercialize your invention and develop it yourself. Another answer could be, well, you want to get a patent because you want to attract strategic partners and get investment to move to another step, to move ahead. And another possible reason could be that you want to get a patent so that you can sell it and make some profit in the short term. And when I say short term, it's probably 2 to 3 years, maybe even 4 years, because sometimes procedures do take longer than the 1 year accelerated period. The reason why you want to ask the question, why do I want a patent? Because you're going to be dealing with relatively high expenses, at least for small inventors, of $10, $15, or even $20,000 to go from point A to point B. So at this point, I thank you. We welcome your questions. You can take a look at our site, contact us by telephone. We'd be happy to help you.
Thank you, Chaim. Thank you. I think it was very encompassing description, and I think people should have like a pretty good understanding of the process and how patenting goes and why it's needed. Working with our customers, we receive a lot of questions related to intellectual property. And if you don't mind, I would like to ask a few questions so we could, some of the frequently asked questions, so we could discuss them before I move to the next section and talk a little bit about us. For example, one of the very popular questions is related to the provisional patent applications. Our customers often ask us what options do they have if their 12-month grace period expired on the provisional patent application. Like you mentioned before, when you file a PPA, you have 12 months to basically like develop your product, test your market, and then file a non-provisional patent application. So what options do people have if they somehow miss that deadline?
Okay, I mean, I first want to emphasize that not only a PPA, but any filing. For example, if you want to start with a non-provisional, and many people do, that also starts the clock with the 12 months. I guess the unique thing about the PPA is that it's never published. It's never formally published anyway. So that if you file your PPA here at time 0, and if for whatever reason you don't do anything, and it's 12 months and a couple of days, you can't extend it. But what you could do, and you'll lose priority. Basically, you lose the rubber band effect where you go back to 0, okay? So you can't get that back. That's something you have to realize. But you can refile a provisional patent application. I've known a few clients over the years that have done that. Kind of strange to me because, you know, you're starting already. Instead of September 27th, 2018, you'll be starting as September 29th, 2019 with your priority. So you might as well, maybe a full application if you've learned. But you don't have a lot of options to use that PPA anymore or to enjoy it anymore. You have to refile if you want to proceed in any way to have additional priority as you go on.
All right, thank you. The other question is related to the prior art. I guess, can you first like briefly mention or like give a definition of the prior art?
Sure. Prior art is I'm sure most people are familiar with the expression state of the art. So, you know, these are formal English expressions, which are, or American expressions, I guess, or I think they use it in England too, that refer to what's out there, how you compare with it. Prior art does not necessarily have to be a patent. It does not have to be someone who's received a patent. It could be a patent application which has never, ever become a patent. It could be a product that's already seen through Google or that people have been advertising in the newspapers. So prior art could be any one of those things. And the reason why prior art is important for two reasons. It affects the novelty of your filing. If someone has a product or prior art out there that was available before you filed, and if it's, you know, close to identical, makes you not novel, that can impact you. Another reason why you need to know about prior art, even if you are still novel, it's good to compare yourself with prior art. The days of having an invention or having a patent application where, you know, you file and you immediately get a patent application, like I mentioned, and it happened to us a year and a half ago on 2 occasions, they're not that common. And the people that develop atom bombs or spaceships anymore, they're less and less common too. What I'm saying is that many inventions today use components and different products and so forth that exist, that are prior art. They may have a unique combination, they may be novel nonetheless, but it's always good to know what's out there, both to understand that you may be novel, and that's very important to know, and also to know what type of obvious or non-obvious combinations of the prior art make up your application. And you can search this in numerous ways. Internet, of course, is the way to do it nowadays for at least the last, I'd say, 10 years.
So would you suggest to look at resources other than the USPTO database, like when you're researching the prior art?
Yep, they're up until recently, and probably there still is available to companies that specialize in searching prior art. That's one way to also go, but you know, you have an expense there too, normally on the order of about $500, give or take. But that's their expertise. You can go with them. I mentioned that because they probably have access to specialized databases, worldwide databases. We frequently work with companies like that, or we search on the USPTO database. Normally, many people in the world do file with the U.S., but there's also a WIPO database, WIPO, World Intellectual Property Organization database, which is even wider than the USPTO, although the USPTO is a bit more user-friendly. And you need to know when you're applying to an application, the concept of novelty, meaning you're the first to come up with, you know, this combination or this invention. It's worldwide. It's not just limited to the United States. So you may be very happy that you have an application applying for a patent in the United States, but if somebody in France already has an invention, already has a patent on that, or tried to patent and published a patent application, 2 years ago or 3 months before you started, then you probably won't get a patent in the United States.
So that means you actually also need to look at international patents, right?
You have to know anything that's out there, because again, the key word is novelty. If you're not novel, and novelty means anywhere, then that can hurt you. So it'd be good to check that first, or at least get a stronger indication. One word about searching, by the way, there's no such thing as 100% surety, although in many cases, a relatively small amount of effort and/or money can help expose, most of the prior art that you have to be concerned about. But you should make an effort to check what's out there, because let me give you an example the other way around. When clients tell me, listen, I've got this idea, it's great, I've got this invention, it'll become a patent, there's nothing like it at all, I already get a little nervous. I'd much prefer to hear a client say, hey, look, I've got this really great invention, but I see these 2 or 3 things that are kind of similar, but we're unique compared to them. That sounds like a good approach. That sounds like a healthy approach.
All right, thank you. And I can mention, like, from our side, when we design a product, when customers come to us with the prior art search completed, and like knowing what's out there, that helps tremendously, because we can see features that are novel, like features that have been patented before, and basically can design a product around that. Or at least would know the landscape that we're dealing with, and that helps tremendously, like knowing what's out there already. And sometimes, like in our practice, there were cases where like a small change made difference. Like we had a case where a customer had a device, and the sensor, like in all the previously patented products, the sensor was separate from the controller, and by putting the sensor into the same enclosure with the controller, that made the difference, and the customer was able to get a patent on that. So
very good.
So doing like extensive research helps, pays back, helps a lot, that's for sure. And I think one of the last questions I want to ask is, so you mentioned that it takes on average somewhere between a year to like 30 months to get a patent, I would say. Like, I mean, obviously depending on on the situation, but what are some of the ways to expedite that process?
Sure. One of the most effective ways to expedite the process is to file a Track 1 application. One of the people listening to the webinar today, and I, as a client of mine and actually friend, that's exactly what we did. We made a first filing for his application in late January 2018, and we were notified roughly a month ago, meaning early September, late August, that he had an issue, and there was an issued patent, and I think it's already issued. So you do the math, a filing, let's say the last few days of January, and the patent being issued in late September, that's roughly 8 months. That's fast. That's very fast.
Yeah, it is.
And we've repeated that a number of times with a number of clients. Track 1 is the way to go. The advantage of filing the disadvantage, okay? Track 1, it costs more. You have to, if you're a micro entity, you're spending about $1,000 in USPTO fees additional, attorney fees also on the addition of about $300 to $500 more. I mean, even the 8 or 9 month fees, and it also frequently affects the prosecution because that moves faster. Another interesting thing about Track 1 and accelerating the process that I've researched, and I found out that the USPTO, of course, publishes statistics on overall all their patent applications, what percentage from applications become patents, because it's not 100%. And then they also publish statistics on Track 1 applications, and Track 1's been around, I believe, for 3 or 4 years now, something of that nature. How many Track 1 applications become patents? And it turns out that the they call it the allowance rate. And when you get when they say you're about to get a patent, that's your patent's been allowed. Okay. The allowance rate for most of the applications, over all the applications, conventionally, is on the order of 60 to 65%, just under 2/3. Lots of reasons why that could happen. It also depends on specific invention, the type of technology, and so forth. But that's the overall statistic. However, for track 1, the number is closer to 90%. And that's astounding. That's like, well, okay, 10% maybe no, but in most cases, yes. I have not read any articles, or I don't have a clear proof why, but I can see from my experience that the reason why this could happen is that both sides are willing to move much more quickly and much more effectively to use the law and to move to get an allowance. Many times in speaking with examiners in situations like accelerated prosecution, we get much more flexibility and much more speed from them. And usually a client that wants to do that is also more serious about really centering on what he wants to get for his patent, as opposed to, trying to go out into outer space. So that's one mechanism. There are quite a few others. There's what's called patent prosecution highway. That's when you get a patent in one place. Let's say you got a patent in France, already have a patent, and you still have time and you file in the United States. You can say, hey, look, in the United States, this is my patent from France. I want you to recognize that and try to accelerate my current application in the United States. That's a little less, what should I say, smooth than the track 1, but it is a relatively new mechanism, and it also, in many cases, helps accelerate. There are a few other oddball ways you can speed things up too, but those are the main routes.
Is it true that older people get priority in the review process?
I'm sitting and nodding my head. That's correct. I believe that if you are over 80 or just over 80, you file in the United States, you get to the head of the line. There's also, in many countries, the United States as well, I believe if you have, I say I believe because I don't have personal experience, but it's on the law books. If you have a patent application dealing with energy savings or green technology in general, and if you have a few other types of categories of patent applications which are extremely important to the government, you can also get out of they call it out of queue. You get to the front of the line, and that will accelerate the prosecution. These latter ones, by the way, are for free. If you are, an inventor and you're over 80, you do that for free. You don't have to pay any additional fees.
Oh, wow, that's something interesting. I guess some people are thinking now, like maybe we should do a proxy, find a proxy.
I have a client. I've actually done some filings for a client, and she's well over the 80. But we haven't gotten to the point where we have an allowance yet. But she would definitely qualify, definitely.
All right. Okay. Well, that kind of makes sense. All right. Well, thank you very much for answering the questions.
Very good.
I think that's very helpful, and we learned something new today. A few words about our company. We are a product design and development company. So we work with inventors as well as established businesses who have different product ideas. So in a way, they come to us with the idea, and like we take it all the way to the market. We design the products, we build prototypes, we help them with marketing materials, and basically like solving all the problems along the way. I guess we can switch to the next slide. Yep. So these are just our core expertise. It's in product design, and like I said, prototyping and design for manufacturing. While doing these things, our customers often face with IP questions, and not only from the design standpoint, but also from the marketing standpoint and fundraising standpoint. For example, the values of the patents do not end at the point where you secured your intellectual property and you can stop other people from building the same thing. There are some other, maybe like indirect values, but for example, by just having the status of your invention as patent pending, increases your chances of securing funding, and that has been proven in our experience. Customers who filed the patent application had better chances of raising funds, because investors are always asking about the intellectual property and if it's secured. Of course, in most cases, they would prefer inventors to file a non-provisional patent application, but even a provisional patent application may suffice in some situations. Also, like the status of product being patent pending can also like prevent some people from starting the same thing. Because nowadays it's a lot about like who gets to the market first, and by securing your priority date and publishing your product allows you to get that first to market status. So, and if someone would come up with a similar idea, they would probably like think twice or maybe even 3 times before they would launch a similar product, because they already see you have a website, you're already in a development process, close to production, so you're way ahead of the game, and it just doesn't make sense for them from the business standpoint to get into developing a similar product. So that's why patent and even patent applications have like another value, not just from just the IP standpoint. So I guess we can switch to the next slide. So yeah, just to wrap up the webinar, like our company, like our mission is to realize our customers' vision. What we mean is like when we work with businesses, we are listening to them. We are trying to develop and provide them with the best solution to their problem and to their fulfill their requests. And while doing that, we obviously use our experience and expertise, trying to make the overall thing better and allow them more chances to have success in the market. We started as a student organization and evolved into a company. So we truly are passionate about product development and building new products and building someone's dreams. So and our, I guess, background allows us to introduce some technical expertise to the process. So I guess that would be it. Chaim, thank you very much for this webinar. I hope we addressed some of the important questions, and I hope this will help someone to either decide to move forward or to think through their process, and maybe please guys, feel free to reach out to Chaim and ask some additional questions related to intellectual property. If you have questions related to product development, you can reach us on our website. Thank you everyone, and please join us for our upcoming webinars. The next one is probably going to be in a couple of months, but we'll be sending newsletters and updates on that. So Chaim, do you want to add anything else?
Nope, I just want to thank you, Konstantin. I was a lot of the things you were mentioning in your wrap up, I was nodding my head, agreeing with you. I also want to thank people for joining us today, and I wish everyone all the success in the future.
Thank you everyone, and have a great day. Bye-bye.
Bye-bye.
Bye.